Okay. Hello, everyone. Welcome. This is Hayley and Murali again with Boshamshire Immigration Law Group. We are an immigration law firm located in Raleigh. We've been doing immigration for about 25 years. If you're joining us again, thank you and welcome back. If this is your first time, thank you for joining us. So today we are going to be covering recent H1B updates that have happened. So the two ones that I'm referring to are the prevailing wages that were just issued in October, and then also the recent update that's been issued, the new ruling on the definition of specialty occupation by USCIS. So that's what we're going to cover. And if you have any questions about that, feel free to comment in this section. We'll answer them at the end just to kind of go over it for specific questions. So let's hop right in. So Murali, thank you for joining me as always. So kind of going back, what is the prevailing wage and why is it important? Why does it matter?
Yeah, so basically the prevailing wage is in existence to really protect US workers. And so for any case, whether it's an H1B case or a PERM case, or even an E3 case for Australian nationals, the company has to prove that it's paying the required wage, which is really the higher between the actual wage and the prevailing wage. And the prevailing wage is determined by the Department of Labor. And basically every July, they update these prevailing wages based on information and data that they have on wage growth or wage decreases in different jobs in different locations around the country. And like I said, that is strictly there to protect US workers, and that's a requirement employers have to follow.
Okay, awesome. And so typically prevailing wages come out in June or July of every year. So what is with this? And I know we had new ones issued back in June, July of this year.
That's
what
right.
happened for them to be issued in October? Like, how is this administration able to do this?
Well, when Trump took office, I think everyone remembers the executive order for Buy American, Hire American. And so based on that order, the Department of Labor has pretty much ultimate full authority to change whatever they need to change if they think that it will protect US workers, and this administration actually has done a lot of immigration, executive orders over the last number of years, as we all know, under the guise of protecting US workers. But ultimately what I think and what a lot of immigration, practitioners think is that they really want to cut down the foreign workforce and really H1B workers in general. And this is one way to do that, Hayley, is to increase the prevailing wages dramatically.
Yeah, and I know I've seen, we do a lot of them so for example, I know I looked up one, it was, I think the software developer, the 151132 SOC code for Raleigh, I believe like the level 1 wage is $100,000. So that's kind of, I know the discrepancy and the difference we've seen between what it was before and what it is now.
So basically, the wages that came out last week on Thursday, I believe, yeah, you're right. They increased anywhere from 30 to 40%. Typically a level 1 wage under a normal prevailing wage is in the 17th percentile. It went up to the 45th percentile. Okay. I mean, that's a huge increase for level 1. And what we see is that the DOL is really trying to restrict workers or not encourage them from hiring any level 1 or level 2, which is basically trying to discourage them from hiring foreign workers, and they basically said that. I'm not guessing this. I mean, they came out and said, we want to raise the wages to cut down the foreign workforce and protect the US workforce. But the problem with that is a lot of these wages are so high now that companies can't, it's not even within the range of what a US workforce worker would work in the same position. It's much higher than that.
So it's a bar for entry for maybe a lot of medium-sized to smaller employers for hiring students who are just out of college, right, typically be in that level 1 range. So how does this affect current H1B workers, those who have approved H1Bs and are working now?
All right, so if you're in H1B status and you're working in the US right now, it does not impact you right now. However, let's say you have to do an extension, fairly soon. And let's say that this prevailing wage doesn't get challenged in court or doesn't get overturned in court, which I think it actually will, because it's clearly an abuse of power. How can wages go up by 40-something% in a down economy that we've had for a year because of the pandemic? But if nothing changes, it's going to impact your extension application because every new H-1B application has to follow the new prevailing wage guidelines.
So that's how it'll end up affecting maybe not those who currently have approved H-1Bs, but should they ever need to transfer, need to amend, need to update their H-1B, then that's when it will become in effect, and that's when it could affect them.
That's exactly right. Extensions, transfers, companies are going to have to look at these new prevailing wage guidelines that they're not used to, even internally for all their workers, and figure out, okay, is this feasible? Because, they can't go and pay an H-1B worker higher that's a US worker at the company for the same or similar job, because that would be discriminatory, So they're going to have to make a lot of decisions, and those decisions might be that they just can't do it. Yeah. And that's the goal of the government right now.
Yeah. So the prevailing wage is also really important when it comes to the PERM process, which we've spoken a bit about. So how does this now affect those who are currently in their PERM process? So the first step we know of the PERM is the prevailing wage. So if someone has already submitted their prevailing wage, those typically take about 3 to 4 months to get approved. Where do they stand right now?
Yeah. So let's say that the company has submitted the prevailing wage, it's pending with the Department of Labor, and let's say that wage, I'm just making up a number, let's say it was $70,000, and the company's fine with that. Now, what the DOL is going to do is adjudicate those prevailing wage requests that are pending based on the new prevailing wage guidelines, which completely changes the entire strategy for the PERM case. We're seeing companies that are looking at this now and saying, you know what, we can't pay these wages even when the person gets their green card, because we all know green cards are forward looking, Yeah. And so things are really changing. And I think that for everyone with pending prevailing wage, applications, the attorneys have to really go back to the company, reassess this and see what's feasible and what's not, because the company might come back and say, you know what, this is not feasible anymore for me.
Okay, gotcha. And then for those who maybe are still reworking, kind of like what you're saying, reworking their requirements for the prevailing wage, that's honestly going to have them go back to the drawing board because of all this change. And so I'm assuming, and I just wanted to confirm, the prevailing wages have taken effect. There's no kind of grace period. They are now in effect. Is that correct?
They're in effect. There is no grace period. Basically, any case you're doing from scratch, whether it's an H-1B or a PERM case, the new wages will apply. So it will change the strategy for the attorneys. It'll change the strategy for the companies, for the employees, for everybody, So yeah, that's something we have to look at. It's not good, because it's obviously designed to discourage companies from doing green cards, from doing H-1s, from discouraging foreign workers from staying in the country or coming to the country. I saw one statistic where it's like 1 million something foreign workers who came to the US in 2016 and 2017, but it came down to like 500,000 in 2017, 18, or 19. So yeah, that downward trend is definitely there, and it's probably going to get worse.
Yeah, and I know that immigration actions like this by the administration have been extremely prohibitive to those who are in H-1B status specifically.
Right.
Very exactly. So I know we talked about prevailing wage, and so now we're going to talk about that new specialty occupation rule that is coming out. I think it's an interim rule now, and we have 60 days before it'll go into effect. So can you tell me a little bit more about what is this new rule? I know you were going through it and you said it was about 100 pages. So can you just talk a little bit about
147 pages, and I'm not going to bore everyone with 147 pages worth of material. So I'm going to summarize it. So basically, the Secretary of Homeland Security has the authority under Section 103A of the INA to enforce and oversee the immigration program in the United States. So I know that what was it, about 4 or 5 months ago, there was a big court case challenging Trump's executive orders on H-1Bs where they lost. The court basically said, the whole employer-employee relationship, you guys are spending too much time on that. Just show that there's a bona fide job offer, approve the cases for 3 years. With the degrees, it doesn't have to be directly related to the specialty occupation. You have some wiggle room there. And so we all expected, at our law firm, well, what's the Trump administration going to do next to kind of fight that court decision?
Yeah.
And I think this is the direct result of that, and it's pretty obvious. So what they have done is, again, with the idea of protecting US jobs, which is 25 pages of 147 pages in that document. And I can go into why they think this will protect US jobs. They go into a lot about how a lot of big staffing companies have abused the program, and paid H1B workers a lot less than the US workers, and the US workers have been, laid off, in favor of H1B workers. And, some of that exists. I mean, we all know that, we've read the articles and everything else, but most of it is on the up and up, from what we've seen. So what this really means is, and what they're trying to do, and I believe this goes into effect December 7th, is that they are redefining what a specialty occupation means, and they're getting very restrictive with it. So instead of saying, okay, you have to have a degree in the field or a related field, they basically took out that related field piece. The degree has to have a direct relationship to the job. So general degrees like engineering, business, liberal arts, things like that, they're saying are too general and don't have a direct relationship to a specialty occupation position. And if you look at it that way, that means an electrical engineering degree person could not do a software engineering job. Not to say they can't, plenty of them do, but the USCIS could easily deny those cases, or someone with a mechanical engineering degree doing a software engineering job. They can come back and say, well, how is a business degree related to a computer systems analyst job? So when it comes to specialty occupation, they are requiring employers, whatever the employer says is directly related to the position, whatever degree that is, they're requiring employers to actually go above and beyond, the call of duty to explain how is it directly related. And that's not how it is right now. And I think that's going to be very, very tough to prove unless you're hiring someone as a software engineer and they've got a degree in computer science. And that's easier to prove, the direct relationship. But most cases aren't quite that clear cut, and the industries are not that clear cut on who they hire. So it's definitely just restrictive in that way. So the other part that they're changing is the whole third-party work site. They are basically saying a third-party work site, this is going to impact a lot of staffing companies, is a work site that is owned, leased, or operated by the petitioner. Not by the petitioner, sorry, but they're excluding like the beneficiary residences from that definition, given the pandemic situation.
Yeah.
And they're also saying that with that restrictive definition of a work site, they're limiting the approvals to 1 year period. So you can't get a 3-year, according to this rule, you can't get a 3-year approval for staffing companies, or any company that places a worker at a third-party work site, which like I said, is a work site not owned, operated, or leased by the petitioner. And that's very restrictive.
And this might be going a little bit more in depth to it, but that seems to be going in direct opposition of what was ordered by the courts, where they had to give the 3-year approvals. And if they didn't, they had to give an explanation as to why. So how do you know how they're able to do that?
They're able to do it under the authority that the Secretary of Homeland Security has under Section 103A of the Immigration and Nationality Act. That's basically what they're saying. They could do anything under that section to reform the immigration system any way they want. And they're also saying that the H1B program that's in existence today, or was in existence, was not the intent of Congress. That, the program was always meant to be for the highest paid, highest qualified foreign workers that US companies really could not find, in the US workforce. Now, I have a lot of opinions on this. We all do. I'm not going to go into all of that, but they're using that to restrict it at this point. And again, just like the prevailing wage interim rule is probably going to get litigated, and this one's going to get litigated as well, because everything that Trump has done when it relates to immigration has been litigated, And I think he's pretty much lost most of the time. So probably these will get litigated and he'll lose too, but at the same time, it's just a big waste on the system. It's a waste of time, it's a waste of money. And honestly, I think the biggest thing outside of time and money is that you're damaging the perception of the United States as a melting pot, because a lot of these foreign workers come here and they go through this very long immigration process, the H1B and the green card and everything else that could take many, many years. But they also all want to start companies, and when they start companies, if they're successful, they create a lot of jobs. And so we're losing that perception of the American dream of coming here and doing well and creating jobs and helping everybody, including our economy.
Mm-hmm. Yeah, I think you make a really good point. This has definitely been it's interesting how the interim rule as of now would take effect a month after the election, which potentially could mean a completely different president in office. So just thinking about how long these decisions now in the final months, are having can have for years to come, especially with how long it takes to litigate.
Yeah, and if the Trump administration were to lose, it's not like Biden can roll back these things with a snap of a finger, and so it's going to have some impact for some period of time, hopefully not too long, because I think these rules are very, very, very destructive to the immigration system and to the U.S. Economy as a whole. But there are a few more things in this reg I want to go over, Hayley, that I haven't gone over yet. The employer-employee relationship, which, again, that court case we were talking about before kind of loosened that whole thing to how it was a long time ago, which is how I think it is. But now they're going back to the whole master-servant common law definition of an employer-employee relationship, which, I mean, in our law firm, I'm probably a servant. I mean, all of you guys are the masters, but which, I think that's a ridiculous definition, the whole right to control idea. And so they're going back and basically reinstituting the 2010 Neufeld memo that we all hated, with all those multiple things we have to prove that an employer has the right to control an employee and their work. And again, this is not going to impact, companies that are not in the staffing industry, but everything that, other than the prevailing wage piece, but the whole employer-employee piece is going to impact staffing companies quite a bit, because this regulation goes one step further. If you place an employee at a third-party work site, you also have to prove the whole time that you're exercising the right to control. And I'm using the word exercise very specifically because, what does that mean? Does that mean you have to have someone else at that work site for the entire period of time, showing that they're exercising the right of control over this H1B employee? It's going to make it very difficult and very complicated for a lot of staffing companies, which is unfortunate, but that's the intention, of the regulation in the first place. So those are the main areas, without going into the minutiae. Of course, they do talk about, site visits and how these USCIS officers can visit every company, every parent, subsidiary, affiliate office of an H1B petitioner if they wanted to, that if you don't comply with the site visit, they could deny your case. I think that's pretty much the case anyway, but this is at least in writing now. And there are a few other things as well, but broadly speaking, this is what the regulation does.
Yeah, I was going to say that reminds me of what was quoted by USCIS's announcement. It had 3 bullets, and one of them did talk about enhancing DHS's ability to enforce compliance with the worksite visitations that they have. Another one that I did kind of want to get clarification on is in the USCIS statement, it said it's going to require companies to make real offers to real employees by closing loopholes and preventing the displacement of American workers. Do you know which part that's really referring to within the new regulations?
It says in the new regulations, it has to be a bona fide job offer.
Yeah.
If it's not a bona fide job offer, even before these regulations, you couldn't get an H1B approved anyway. I mean, for every H1B case, there has to be a bona fide job offer. So I'm not exactly sure what they mean by that, other than they just want to put it put it in the regulation because they can use that to say, all right, if you are placing someone at a third-party work site, and you can't exercise the right of control the entire time this person's going to be at the third-party work site, then you don't have a bona fide job offer. So they hit all of those three things that they can use to deny cases. That's my educated guess.
Okay, yeah, I know that was three things that they highlighted, and I just want to see how it correlated. So I did just want to say, if there's any questions anyone has, like, please let us know. I think that's really, I think you did a really good job, Murali, about highlighting what's the most important parts of that new specialty occupation item. I know that in the next coming weeks, months, definitely within the next 60 days, we're going to really kind of figure out what's going to happen with both of these new announcements. If they're going to be litigated and stopped, kind of like what we saw with that Hail Mary pass of the new USCIS fees, which I think was 2 days before they went into effect. So I know that in time, I'm sure everything we're talking about now, it could completely change. Who knows? I know that it's a continuing development. Hopefully we'll have more answers than what we do now. Because right now I know it's just kind of a planning aspect of it.
Yeah, I think that the whole specialty occupation, third-party worksite, employer-employee relationship piece of the reg, there's 2 months to go before that goes into effect, right? And I'm sure within that 2-month period, it's going to get litigated, and we're going to see what happens with it. It'll, the election's going to happen as well fairly soon. That could have an impact one way or the other on what goes on with this. But from a immediate standpoint, it's really the prevailing wage, interim rule that has the impact, right? Because companies have to deal with that now, assuming, and you can't assume it's going to go away. I mean, I think that it probably will through litigation, but, companies in law firms can't assume that. And so I think everyone needs to get together and figure out, okay, do we have any H1B extensions that have to be filed, let's say, in 1 month? Because we know employees want to file H1B extensions at least 6 months prior to the expiration date, which is good practice. But maybe now, looking at it, file it 5 months prior, just wait a month and see if there's any news that would overturn these new prevailing wages, because I can tell you it's going to be very, very prohibitive to a lot of small to mid-sized companies, even some large companies, but it's definitely going to have a significant impact. And that was the purpose of the DOL issuing it now.
Yeah. So we did get a question. So I did just want to kind of go over that with you. Does the prevailing wage update affect those who have an approved I-140? Is it going to affect them kind of in their current I-140? I know that we talked about it is going to affect renewals of H1Bs, but kind of with someone who has an approved I-140, does it have any bearing on them whatsoever?
It does not, because they've already gone through the prevailing wage process and everything else. It doesn't impact anybody who already has a prevailing wage approved and is about to file the PERM. It doesn't impact people who have approved PERMs already. It's just going to have an impact on pending prevailing wages and any new PERM cases that are initiated right now and moving forward.
So only if they, switch from EB3 to EB2, if they change employers and have a new green card process for them, that's only really when the prevailing wage will affect them when it comes to the PERM process and the I-140 process.
Well, let's differentiate switching from EB3 to EB2. Yeah, if you do it that way, you're going to have to start the PERM process over again, and it would have an impact on that. It's not going to impact what's going on right now in the month of October, which is the EB3 to EB2 downgrades.
Thank you.
Because, yeah. So I just wanted to clarify that.
Yeah, definitely. I know with all those questions, I could probably confuse some people. So thank you for clarifying on that. So I hope we provided clarity on that question. I'm just going to make sure before we hop off that if there's, we got a few more. Prevailing wage is approved, but their PERM is not filed yet. Is this going to affect their PERM process?
It should not, because the prevailing wage has already been approved.
Awesome.
Yeah.
Oh, this one, we just got another one, and it just kind of goes back to, will this impact postdocs who have their H1B renewal due in a few months. So bearing no current legislation that would impact the current new prevailing wages, it will have an impact on new H1Bs and H1B renewals in the coming months, because there will be those new prevailing wages that the LCA and the employer has to comply with. So thank you for that question.
Thank you for answering it, Haley.
That's what I'm here for. Okay. I did just want to give a few more minutes. Murali, I did want to also talk with you. Is there anything kind of you wanted to also talk about the H1Bs that are going on right now that you wanted to bring up kind of before we hop off?
Well, we've gotten a lot of questions on will this impact, and I think we've already gone over this, but I don't mind going over it again, which is, are these going to impact, the cap cases that are still pending for this year, and the answer is no, because you've already got approved LCAs for those cap cases, and most of them are already pending, and the ones that have to get filed very, very soon, before the November deadline. So the answer would be no on that. Unless you have to file a new LCA, then the answer would be yes, it would impact those cases. But I think right now, I think it's just more of it's just kind of a shock to the system. And again, I think all of these, the prevailing wage and the redefinition of the specialty occupation and in the direct degree that's required for it, it's meant to be a shock to the system. It's intentionally meant to be a shock to the system. And it's just, we have to all get through it. I mean, it's not going to be easy for companies or foreign employees or law firms or anybody else. But I'm optimistic that the American immigration lawyers and other interested parties will litigate both items and will probably win.
Yeah.
This might take a little bit of time.
Be successful. I completely agree. I feel, even though with this, I do feel quite optimistic about it, just because we do have such great advocates on our side fighting for immigrants and the immigrant population. So I'm very happy to be part of that community as well.
Yeah.
Okay, awesome. Well, it looks like we don't have any more questions, but if you do have any additional questions, please feel free to reach out to us. You can message us on Facebook. You can also reach out to us through our website, which is www.boshamshaw.com. You can send us an email. You can call us. You can also sign up for our newsletter while you're there. That comes out every Monday at noon, and it's just the most up-to-date curated immigration information. So just talking about this, you would know about upcoming videos, immigration webinars like we have today, and any in the future you'll be made aware of. So just if you want to stay up to date on immigration, you feel like it's really pertinent to your life, I encourage you to sign up. But other than that, thank you for joining us. Murali, would you like to say anything else?
Thank you for everyone, who listens into these, Facebook Lives that Haley does a fantastic job with. She does a fantastic job with the newsletter. So yeah, do sign up, stay abreast of the news, and let's hope for the best.
Yes, let's hope for the best. Okay, wishing you all well. Have a wonderful rest of your day. Thank you so much, Murali. Bye-bye.
Take care, Haley.